Despite the COVID-19 pandemic disrupting almost all professional events, on July 23rd, Legal Plus and L2 Icon jointly managed to hold the fully virtual Construction Claims and ADR Conference 2021. The conference was participated by 44 moderators and speakers from 9 jurisdictions. With such a star-studded lineup, we had high hopes the conference would be a success, and true enough, the conference achieved its target by seeing an incredible 1,534 registrations. Not only that, the conference also set a new record in the Malaysian Book of Records for the longest non-stop virtual construction and ADR conference, when the conference ended after a 12-hour marathon at 9 p.m. Although the conference ended on July 23rd, its impact is still ongoing, and it is why we organized this charity premiere to let the conference see the light of day again, and at the same time to show compassion and empathy in our community. Let's watch the show together. It was this experience that became the spark for us wanting to help more people. We approached charitable organizations that help feed the poor, needy, homeless, orphans, abandoned, refugees, mentally disabled children and adults, the handicapped, animals, medical care, and help for children's education by providing used laptops and computers. If there is one thing we learned during the course of this initiative, is that there are many good people in our society, and many charitable organizations are going above and beyond to help those around them. For this charity premiere, we have carefully selected 10 charitable organizations, and we implore you to donate. Even a small amount goes a long way for them. 100% of the funds collected will be distributed equally. This initiative also helps raise awareness, the work these organizations do, and the people they have an impact on. This is the very reason why we are organizing this charity premiere, and with your help, we can help those who help others. Previous court rulings can set a precedent for many cases in the future, and is the reason why lawyers and those from the construction industry should pay close attention to it. Our panel of experts will discuss the verdict of 4 recent notable Malaysian cases and how they have a far-reaching impact on the construction industry.
Ladies and gentlemen, it is now time for us to go to session 2. It is part and parcel of our professional practice to keep up to date with the developments of the law. In session 2, we will be exploring the legal ramifications and fallout from recent decisions of the Apex Court in Malaysia. We are honored to have Justice Dato' Lee Swee Singh as our moderator for session 2. Justice Dato' Lee needs no introduction, but please allow me to share a brief introduction. Justice Dato' Lee was in active legal practice as a member of the Malaysian Bar from 1985 until 2010, when His Lordship was appointed a Judicial Commissioner of the High Court of Malaya. His Lordship is now a judge of the Court of Appeal of Malaysia. Ladies and gentlemen, please welcome Justice Dato' Lee.
Thank you, Hui Ming, and a very good morning to all of you out there. I guess it would be appropriate for me to welcome you to this historic event that we are all a part of. It is a first in many ways, I was told, a 12-hour non-stop construction law conference where you have the benefit of input from some 34 speakers from 9 different jurisdictions. We should explore together a vast array of issues during this conference, issues within the construction industry that affect all of us. The pandemic has disrupted many things, and construction industry and the legal industry is no exception too. But a disruptor can be harnessed to become an accelerator of change and of growth. The courts are moving from paperless to paperless, and I trust the lawyers and the construction industry are too. When I first started practice in 1985, and when I joined the judiciary some 11, I never could have imagined that one day I could do the whole gamut of legal work online and even hearing cases online. I remember telling my friend, my work is such that I need to go to office to work, and I'm glad that I've been proved wrong. Really, I was looking at what I would bring along with me when each morning I would click in on the Zoom panel to hear my cases from my desk at home. I have 3 devices, a notebook for the Zoom, an iPad for me to type essential notes and to open my own documents, and a handphone to contact our registrar if there is a problem with the connection or a need to confer with fellow members of my panel on issue of calls and things like that, without the need to be put into the virtual annex room. Yes, I don't have even a piece of a hard copy paper with me. We are really going truly paperless. Going online has helped to reduce costs drastically. And I gather that this conference is priced very reasonably at only 100 ringgit, with far more benefits in terms of learning from a greater number of speakers. A case of where the reduction in cost is passed down to consumers. Coming back mainstream to the topic at hand, legal ramifications and fallout from some recent decisions of our apex court. Fallout, as you can imagine, is a very graphic word. You can imagine an implosion or explosion of both, with serious consequences affecting all and sundry. The courts do not court controversies, but we appreciate that some of our decisions, called these landmark decisions, would have serious ramifications on the ground. An appellate court, it is said, has the right to be wrong. But believe me, all of us would agonize to try as best we can to arrive at a decision that is fair, just, and reasonable by applying the law to the facts of the case. And none of us are perfect and infallible, and so our decisions may not be perfect and certainly not infallible. This side of the world, we can only approximate towards that which is perfectly fair, just, and reasonable. This morning, we focus on 4 landmark decisions in the construction industry. They are the Legenda Unggul's case, the Jack-in Pals case, the Cubic Electronics case, and the Far East Holdings case. I won't read the CVs of our speakers to you because you could read them for yourself. And as we all know, it is written by the speaker about the speaker. Nothing derogatory is meant, not that there's anything wrong with them, but I think for the limited time that we have with us, we are more concerned with what they say rather than who is saying it, all right? And my moderating will be quite different from that of Justice Dr. Mary this morning, and simply because I'm constituted differently from her. And I'm not as interactive as she is, and I don't apologize for that because I need to be me. And so the structure that we look forward and can expect this morning would be Junliang will do the first case involving his commentary on the Legenda Unggul, followed by comments from Hong Ling and Nitin Nakani, and then Hong Ling will deal with Jack-in Pals case, followed by comments from Junliang and Nitin, and then Nitin will focus on the case of Cubic Electronics, followed by comments from Junliang and Hong Ling. And then we have also the Far East case where 3 of them will comment on, and then we have the general questions from the floor. So without further ado, let me now invite Junliang to take the floor, as it were, and to deal with the case of Legenda Unggul. Over to you, Junliang.
Thank you, Judge. Morning, everyone. I'll be taking on the case of Pembinaan Legenda Unggul. Let me share my screen for some slides. All right. The central issue, or rather the subject matter of Pembinaan Legenda Unggul is the retention sum in a construction project. Now, Legenda Unggul, Pembinaan Legenda Unggul, as you see on the screen, was decided by the Federal Court in 2019. It is hardly a new decision because the Federal Court upheld the decision of the Court of Appeal, which I think was reported sometime around 2017. Now, what the Court of Appeal had done, just to give you a summary, is to reverse an earlier decision in Kimonda. Kimonda was also a decision of the Court of Appeal, but that was the decision in 2011. So one could say that in 2017, the treatment of retention sums in the construction industry was given a vastly different complexion by the decision of Pembinaan Legenda Unggul in the Court of Appeal. Now let's have a quick look at what are the facts. The facts are not controversial. The facts in Kimonda as well as Pembinaan Legenda Unggul or Pembinaan Legenda are slightly different. In Kimonda, there was an application pre-liquidation to secure funds, the retention sums, and the High Court and the Court of Appeal allowed that application. So the retention sums were placed in a trust account. By comparison, in Pembinaan Legenda, the employer had already been liquidated. There was a voluntary liquidation, as you can see on the screen. And at the time of the voluntary liquidation, the employer was still holding on to the retention sums in an account which was not segregated. So it was commingled with the rest of the monies. Now, upon liquidation, what two sets of contractors tried to do is to seek an order for the employer to preserve the retention sum monies held on trust. Now, what happened in the High Court? The contractual provisions are important, and you will see right at the top of your page the main provision which deals with retention sums in Pembinaan Legenda, which is this: unless otherwise stated in the appendix, each and every payment for interim claim shall be subject to a 10% retention sum to the maximum limit of 5% of the subcontract price. No mention of any fiduciary relationship, no mention of any trust to be created, and certainly the retention sum is not meant to be placed in a trust account. There was no contractual obligation. So the issue simply is this: are retention sums held on trust without more? The High Court felt bound by the decision in Kimonda. In Kimonda, the Court of Appeal said this: the retention monies are by their nature and purpose trust monies held by the appellant for the respondents for a specific purpose, i.e. for payment on the costs incurred by the appellant to rectify defective works by the respondents or to complete the works left uncompleted by the respondents. So what the Court of Appeal in Kimonda looked at and gave focus to appears to have been the nature and purpose of retention sums. Then came the appeal before the Court of Appeal. In a fairly lengthy, reasoned judgment, the Court of Appeal departed from Kimonda. And the first thing the Court of Appeal looked at were the authorities that Kimonda had relied upon in arriving at their conclusion that retention sums are trust monies. Now, the decisions or the authorities that Kimonda had relied upon, which you'll see in the second bullet point, React Construction, Mac Jordan Construction, and a Malaysian case, Kumpulan Lizis, were all cases where there was an obligation to create a trust account, to place the monies in trust. In Kimonda itself, as was the fact in Pembinaan Legenda, there was no trust because the lack of an express clause or clear conduct of parties. And as a matter of fact, in this case, the retention monies were never segregated. Contrary to what was held in Kimonda and the approach taken in Kimonda, the Court of Appeal here looked at the principles on which a trust can be set up, and it concluded that a trust cannot be implied purely from the nature and purpose of retention monies. It went on to observe that most construction contracts do not operate via a trust unless otherwise expressly stated, but at the level of a contract and a debt. A debt is a chosen action. And we'll come back to that in a moment when we look at the decision of the Federal Court. Being practical about it, the Court of Appeal recognized that one need not necessarily have expressed words to create that trust. That was not a necessity. Of course, it helps. It went on to hold that a trust fund may not come into existence just because a contractual clause provides for it. And this is key. There is a clear difference between an intention to create a trust and the creation of a valid trust. We will look at some English decisions in the next few slides. Now we look at what the decision of the court or the federal court was. The federal court upheld the decision of the Court of Appeal and largely agreed with the reasoning of the Court of Appeal in Pembinaan Legenda. The federal court held that Qimonda was wrongly decided. Qimonda had relied upon cases in which the facts required the creation of a trust in respect of the trust monies. Now in Mac Jordan Construction and Wilmot and Elton, these cases concern the UK JCT contract. And for those of you familiar with some of our local standard form contracts, such as the PAM contract, you will recognize the opening phrases of clause 30.5.1 of the JCT form. The employer's interest in the retention is fiduciary as trustee for the contractor for any nominated subcontractor. So the issue is whether this clause is in itself sufficient to create a trust. Now, what these English courts held is that this provision only imposes a contractual obligation to appropriate and set aside a trust fund. Where parties have agreed by a contract for the retention monies to be impressed with a trust, it is vital for the trust to have been established before the employer's insolvency. So to summarize the position taken in those English decisions, the contractual provision creates the contractual obligation. What parties will need to do is to proceed to set up or insist on the trust being set up. And that must be done before the liquidation of the employer or the party holding on to the retention sums. So these are the principles that the federal court distilled from Pembinaan or in Pembinaan Legenda. First, an agreement must employ sufficiently unambiguous terms to show that a trust is created with the contractor or subcontractor as the beneficiary. Two, while an explicit clause creating a trust may be of help, it does not mean that an absence of such a clause negates the existence of a trust. And this is consistent with what the Court of Appeal had held. There is no presumption that monies held in a separate account must necessarily be held on trust. Four, at any rate, each case depends on the party's specific intention as expressed in the relevant construction contract. And lastly, even where there is a fiduciary relationship between an employer and a contractor, not every fiduciary is a trustee. And this is key when interpreting the JCT form as well as your PAM forms, because those contracts are examples of where a fiduciary relationship is referred to. The federal court also looked at the principles of a private trust, and these are the elements that are necessary for a trust to be created: certainty of word, certainty of subject, certainty of object. So on these very basic principles, the decision of Qimonda could not have been correct. Now, this is a decision that comes out from the Court of Appeal of Hong Kong, and it really gives us a complexion or a look as to how trust monies or retention sums should be treated and why it shouldn't be treated as trust monies without more. The Court of Appeal held as follows: to allow a creditor or a restitutionary remedy in the interest of doing justice in a specific case would only lead to that creditor jumping the queue of unsecured creditors and so bring about injustice in everyone else's case. And I come to the end of the case of Pembinaan Legenda, and I pose you these three questions. What is the underlying concern? The underlying concern must be the security over the retention sums, which are still held by the employer or are withheld by the employer. But is there a larger problem? Does the solution lie elsewhere? Now, if we think about it, the retention sum is part of your certified monies for work done. Certified sums, whenever they are paid, even if there is a delay in payment, are not treated as trust monies. if the employer goes under after certification is done and before payment is made, the contractor will similarly rank in pari passu as together with the general pool of creditors. Now, the retention sums, as we know, is part of those certified sums. So why should they be treated separately? Does the solution lie elsewhere? If the concern really is securing the funds for payment of the contractor for work done, is the solution to be in the form of a payment bond? There are performance bonds that are given by the contractor or secured by the contractor for the benefit of the employer. Vice versa, should there be a payment bond that is secured by the employer for the benefit of the contractor, such that if in the midst of works, whether it concerns the certified sums in general or whether it concerns the retention sums, if in the midst of all that the employer goes under, the payments due to the contractor for work done can be secured. And perhaps that is the solution. I end with this. In Pembinaan Legenda itself, the federal court observed that in the various states of Australia as well as in New Zealand, there is legislation to require retention sums to be placed on trust. Is this a solution? I'll leave you with that. Thank you.
Thank you, Jun Young, for the short and succinct treatment and critique of the case. And now I would like to invite Hong Ling to critique on your critique. Yeah, over to you, Hong Ling.
Good morning. Good morning, Judge and the panelists and everybody. My personal view is that I'll prefer the approach taken by Kim Onda, because I think we need to look at this not merely being an issue between two contracting parties, because ultimately the retention sum being held by the employer pretty much is accumulation of all the retention sum that has been held downstream. So it cannot be that at one level it is a trust because you have a very sophisticated contract that provides for that. But for the same amount of money, one level down, because your letter of award is just a 2-pager, therefore it's not a trust money. So I find that treatment difficult because this money essentially is where the plumber's money, is where the electrician money, and all pulled together. And that's where the main contractor has that money to be held by the employer. So in my view is that the default rule should be that these money are actually to be classified as a trust money because those are money earned and merely being kept, the employer having custody of the money for very specific purpose in the contract, which can still be exercised. That is not in doubt. So the nature of that money should not be changed just because of certain provisions or certain acts taken by the party. So for example, if the contract says that you're supposed to put this in a separate account, but the employer did not do that, or the employer merely say that he's going to do it, but never do it. And then because of that, based on the decision of Pembinaan Legenda, that would not be properly classified as a trust money. So we will have the practical difficulties there, which is why I feel that the default rule should be that this is a trust money, but parties can elect not to have that trust. So it's an opt-out rather than the opt-in mechanism, taking into account how the industry works and taking into account how that retention sum is. So this is how I view the treatment of retention money. Yes, I think Junior's point that there will be a little gap that, hey, look, what if you certified and then the company got wound up, your certified sum, you got to join the queue. How is it that your retention sum has now become a different treatment, that become trust and you will get preferential treatment. But I think that is just because that is the nature of a retention sum, as simple as that. So yes, it is from the certified sum, no doubt, but within the certified sum, this is this specific species, which is retention sum, which the employer have the right not to pay yet, but nevertheless, it's money earned by the contractor. So this is my view on the case. Thank you.
Yeah, thank you, Hong Ling. And now we invite Dr. Niting to give us his comment and critique. He can critique on the critique of Jun Liang and the critique of Hong Ling.
Thank you. Thank you, Judge, and good morning to all the participants, 1,300 participants. There's no doubt that there is a need for protection of these monies, which really, in a moral sense, belong to the persons who have done the work, who have earned the money, and who may find through no fault of their own that all of that money is later on, if the employer goes into liquidation, all of that money goes into the hands of bankers to fatten the bonuses of the bankers who already earn far too much money. So I accept that as a moral position. But how does one implement it? Do we engage as Qimonda? And I have some knowledge of this because actually it was my firm that lost Qimonda, acting for those super fatted bankers. Do we do it by looking at the terms of the contract and the relationships entered into between the party? Do we do it by putting political pressure on our political masters to amend the legislation? Or do we invite our judiciary to enter into what Justice Suryadi described in Muhammad Ridwan against Asma as a judicial activism? In other words, do we want a Supreme Court like the United States or other jurisdictions who make up law to fit the morality of the situation? Speaking for myself, and I remember this is a question that we used to be asked in law school all the time about hard cases making bad law. This is a hard case. There is no doubt that that money by any moral standards belongs to the contractor and down the line to the plumber and the electrician. But I think the federal court was right. They looked at the contractual arrangements made by the parties and they declined to enter into a Denning-like activist position and rewrite that contract and left it to the parties to resolve these. And it's quite easy to resolve these. All of these are standard form contracts. There is nothing to stop the organizations that create these standard form contracts, the Architects Association, the Engineers Association, CIDB, the AIAC, to make it clear that these funds are trust funds and that they must be kept as trust funds and that they must be kept separately as trust funds. There is nothing to stop Parliament to create a trust account, as they have done in the case of the housing developers account, where that money has to be segregated and used for only specific purposes. But once we go down that slippery path of judicial activism, it won't end merely in this situation. So I'm afraid that I tend to think that the federal court got it right on the law, although there is a strong case for amending the law and amending the contracts. Thank you. That's my little 2 cents worth.
Thank you, Nitin. Some questions have already come in. We will hold our horses because we want to complete the 4 cases first before we take the questions. So I'll pass on to Hon Ling to do his critique on the Jack-in Piles case. Hon Ling, over to you.
Thank you. I hope all of you can see the screen, that the slides are on the screen. So the next case is the Jack-in Pile and Bauer, relatively new case, 2020, and certainly have, I would think that have a really wide implication because SIPA has been around for quite some time and really is something that a lot of contractors resort to. So, but because it's being a new act, so that there will be a lot of areas which we consider the so-called gray area that require some time to go through the court process, probably to go all the way to the federal court and come with some definitive decisions. And so this is one of them. So the key questions in Jack-in Piles is whether the SIPA Act applies retrospectively or prospectively. But the more specific one, or a certain cutoff point when we talk about retrospective and prospective, is that whether the Act applies to all construction contracts or there is a specific cutoff or reference point, and if there is such a specific cutoff or reference point, then when is that? This case also deal with the issue of substantive and procedural rights, and so has been the cases before this SIPA Act. And the uncertainties at that time when the Act first came into force without any guidance from the court, and I'm not talking about the Jack-in Pao case yet, the uncertainties posed at that time was quite challenging, I would say. And I think even AIAC or back then KRRCA will also have to take certain positions in respect of what are the cases that will fall within the adjudication. And at that time, of course, they also took, AIAC also took their own interpretation of what it is. And this difficulty or this confusion was only resolved when the Uda Holding case came along. Uda Holding case started at the High Court. It was appealed against and the appeal was dismissed. So in that sense, we all take it that the decision at the High Court was almost equivalent to a decision or endorsed by the Court of Appeal, although no grounds were written, was issued for the Court of Appeal decision. So in Uda Holding case, the key points that we pick up from that is that, number one, the Act applies to all construction contracts, including those made before the Act came into force. The reasoning for that is that when we read the Act, the Parliament legislated by reference to construction contract. So the question is, are you a construction contract? That's it, because that is what the Act says will trigger the operation of the Act. So not so much of when do you enter, but of course the construction contract have a specific definition. So certain type of contracts which we didn't in our logical mind think that is construction contract, nevertheless, they are still considered as construction contract. So that is how the Act is being packaged. So the question is really, do you have a construction contract? If you have, then the Act is triggered. The court also considered that the SIPA has saving provisions in terms of excluding certain contracts. So the same logic is that if this is meant to cut down the scope of the construction contract, to exclude those construction contracts entered into before the Act came into force, then that probably should have been captured by certain savings provisions, which there was none insofar as the time for entering into the contract is concerned. A view was also taken that the SIPA is a procedural legislation, and typically procedural legislation that can be applied retrospectively, and also the fact that it is a social legislation, so that it should be interpreted liberally and purposefully, and specifically to address the issue sought to be remedied by this Act, which is to aid the cash flow. So that's why this remedy should be available to as many people or as many contractors who have a construction contract who were facing this problem as possible. So that was the logic in the decision arrived at Uda Holdings to say that it applies to all construction contract regardless of when it was entered into. So for the longest time, that was the decision, and that's what everybody follows. So even though you will have a construction contract that signed in 1980, say for example, and the claim is still ongoing, don't worry, you can still go for SIPA and you can still start a SIPA. So all stakeholders, the industry, administrative authority, AIAC, adjudicator, they decided cases on that, counsels, even judges, we all proceeded on that basis. Now, a point to note here is that it is not just about the cases, how it is done, but also how contractors, employers, and everybody conduct their affairs. They will be thinking that, yeah, look, if I don't pay this amount, say for example, if you have a case, the contract that was entered into in year 2000 and there's money due and owing. So you'll be thinking back then, it's okay, I don't need to pay because if you bring me for arbitration, I can buy myself another 5 years. So, but now because of the decision, they may just bring me to adjudication and the case will finish within 3 months. So you will now have to plan and operate your business in that mode. And that's how our affairs of these companies are being conducted and regulated. Then came Jack-in Pao. Now in Jack-in Pao, the key facts are this. First, the contract was entered into before SIPA came into force. And there is a pay when paid clause. And we know that under Section 35 of the SIPA Act, pay when paid clause is now void because they are considered as conditional payment clause. So nevertheless, adjudication happened and the adjudicator followed the decision that because SIPA Act applies retrospectively, so even though this contract was entered into before SIPA came into force, by virtue of Section 35, the pay when paid clause is null and void. So that cannot be a reason or a justifiable reason for the employer not paying for the main contractor not paying the subcontractor. So because of that, a decision was given in favor of the subcontractor that the claim is successful. And this case went on appeal. And at the court appeal, the focus of the court was whether or not SIPA involves substantive right. And this substantive right specific to this case are more in relation to the issue of the Section 35, the pay when paid clause. And the court found that under Section 35, pay when paid clause is outlawed or it becomes null and void. And this pay when paid clause, it being null and void, is actually taking away a substantive rights of the parties, because parties actually have this right, or the main contractor in this case have the right not to pay until I have been paid. So that right disappeared. So because of that, the court of appeal found that SIPA Act should apply prospectively, and that being the case, appeal was allowed, the decision was set aside. So on the face of it, this looks like a departure. If we just look at the big title, that whether SIPA Act applies retrospectively or prospectively, this looks like a departure from Uda Holdings. And this case went on to the federal court, and the federal court upheld the decision of the court of appeal, and the adjudication decision was set aside. Now, the reason given by the federal court pretty much in line in many aspects with the court of appeal. The Act deals with substantive rights and hence cannot apply retrospectively unless there is a clear legislative intention, and such intention is not expressly stated in the Act. And therefore, it cannot be presumed that it will apply retrospectively. In fact, it should be the other way around, because it involves taking away the substantive right. Prohibition of conditional payment is not procedural, but actually it deals with the substantive right because it affects the freedom to contract. And Uda Holdings failed to appreciate the lack of provision in SIPA Act that will allow it to apply retrospectively. And the federal court disagreed that SIPA is a social legislation, and therefore the interpretation given to social legislation cannot apply to the interpretation of SIPA Act. And the court also considered that it will be unfair for the prohibition for conditional payment to operate retrospectively, because you have been acting in accordance with that, and that was a risk allocation that parties have agreed to. And specifically in this case, it was never objected to. So the conclusion is that SIPA applies only to construction contracts entered into after SIPA came into force. Now, the last point here, that is the leave questions posed. So although the substance of the dispute relates to Section 35, the leave questions was not confined to Section 35. Only the second leave questions was confined to Section 35, in the sense that if somehow SIPA also applies to contract that came into force before, SIPA also applies to contract that entered into before it came into force, then whether Section 35 on the prohibition of conditional payment applies only to contract after the Act came into force. So it's a two-tier question. But because the first question is already answered in the affirmative, or in the judgment it says negative, but because the question is posed differently, so the second question becomes irrelevant. So if we look at the answer given by the federal court of the question posed, then the conclusion is that SIPA, as a legislation, applies to construction contracts and only apply to construction contracts entered into after the SIPA came into force. So this is clearly the position now. Now, with this decision, it changed the landscape, obviously, because now there is a category of construction contracts that will escape the clutch of SIPA. Back then, as long as there is a construction contract, you're caught by it. So now there is a category of construction contract that will not be caught by it, and this category of cases are those that relate to construction contracts entered into before the Act came into force. Now, of course, it affects the ongoing adjudication and adjudication-related court proceedings, because these adjudications and proceedings are likely to be decided based on UDA, or at least even those that if these are cases that is decided or ongoing before the Court of Appeal decision of Jack Impao came in, it was all decided based on UDA. So question is that, what do we do about it? It may be easy
you
to
have
just say that,
2 minutes to wrap up.
yeah, I'll do that. So it may be easy to say that, look, now because of the decision, I will dismiss the claim, I will allow the claim, I will allow the appeal. Yes, that may well be the case. But when we need to deal with the consequences as well, because, for example, people may have stopped work based on an adjudication decision, stopped for 6 months, but this contract was entered into before the Act came into force. So what will happen to the 6 months stoppage of work? If this is a decision that is not supposed to be made in the first place because it's outside the Act, and surely the contractor will have no right to rely on Section 29 and say that I want to stop work and claim for extension of time. So this creates a myriad of a practical problem and practical issues that we are bound to face for quite some time to come. So thank you, Judge. I've concluded my
Thank you, Hon Ling. Yeah. We shall now call upon Jun Lian to critique on what Hon Ling has said, the factors for and against, and what people on the ground are experiencing at hand.
Thank you, Judge. I can only speak about what we have been experiencing, both as party representative as well as adjudicators. In respect of when the decision of Bauer of the Federal Court was pronounced, we've had matters where perfectly reasoned adjudication decisions which didn't fall under any of the Section 15 provisions were set aside because of our jurisdictional issues suddenly came about. And certainly 1 or 2 adjudication decisions which I had written, relying on, I would say, the decision of the Court of Appeal in Bauer, also fell because of the decision of the Federal Court. Now, I understand the general view is that the Federal Court upheld the Court of Appeal's decision in Bauer. I have it on good authority, I would say, that that was not what the Court of Appeal had meant. The Court of Appeal was looking at it purely as a Section 35 argument. The Court of Appeal did not go so far as to decide that the entire Act was prospective only. I think the facts speak for itself, and the fact that the bulk of the arguments before the Court of Appeal and the deliberation of the Court of Appeal was on whether Section 35 could be retrospective speaks for itself. Otherwise, the Court of Appeal would simply have said that the entire adjudication decision cannot stand simply because it was entered into prior to SIPA coming into force. There wouldn't be a need to carve out and discuss Section 35. And that is one point. The next thing, certainly with the decision of Bauer, and as Hon Ling had correctly pointed out, the impact goes beyond adjudications that are pending and adjudication decisions that have completed. Now, one aspect of it is this: there is no timeline for an application to set aside an adjudication decision. The only measurement of that is if the adjudication decision has been registered or enforced. Now, of course, I think in the course of Tan Sri Cecil's opening address, he mentioned the Kuantan decision, the Majlis Perbandaran Kuantan and Kining Exeter decision. In that particular case, the adjudication decision that came out in 2017 had been enforced and payment had been made. And subsequently, an application was made to set it aside. Justice Lim in the High Court decided that that was no longer a live decision that would be affected by Bauer. And that is notwithstanding the retrospectivity of the Bauer decision, because it cannot affect concluded matters. Now, I understand from counsel who argued Bauer as well as IRECA as well, that in the course of arguments, or I think when decision was being pronounced, counsel had addressed the court on whether there is a need for prospective overruling of the Bauer decision. And the federal court had indicated that this would be dealt with in the written judgment. But as we all can see from the written judgment, it's not been dealt with. So up until today, although Bauer was reported in 2021, up until today, I think we're still dealing with the aftermath of Bauer.
Thank you. And Dr. Nitin, your comment, please.
Thank you, Judge. I have to agree with Jun Liang on this one. And I go back to a basic principle that I learned in my first year of law in English legal systems, but which has very recently been restated by Lord Carnwath in Crown against Lewisham London Borough Council in 2014 in the UK Supreme Court. And what his lordship said at para 95 was, in my view, this case provides an opportunity for this court to confirm that settled practice may, in appropriate circumstances, be a legitimate aid to statutory interpretation, where the statute is ambiguous, but it has been the subject of authoritative interpretation in the lower courts, and where businesses or activities, public or private, have reasonably been ordered on that basis for a significant period without serious problems or injustice, there should be a strong presumption against overturning that settled practice in the higher courts. So we have a situation where for a considerable number of years, everybody understood that SEPA applied. We're not talking about Section 35. I have no problem with the decision on Section 35, but everybody understood that SEPA was a procedural matter, that instead of going to court or arbitration, this was another statutory dispute resolution process. You could resolve your complaints and your disputes through SEPA. People organized their affairs on that basis for many years. And then suddenly you have a situation where the federal court has reversed that decision without regard to what has become the commercial practice, without regard to the fact that there may be many organizations that chose to go to SEPA and, having gotten a SEPA award, didn't bother to go to arbitration and may now be time barred in arbitration or in court. So, you know, with the greatest of respect, while the decision of the federal court may have been a technically correct decision, had it been decided within a year or two of the legislation being promulgated, at this point in time, when businesses have relied on it for so long, that should have been a matter that the federal court should have taken into consideration. At the very least, if they were minded to take away a process which parties and businesses have relied on for so long, they should have made the ruling prospective so that it would not apply to pending matters in SEPA.
Thank you, Dr. Nitin. And because time has caught up with us and overtaken us, Nitin, could you then deal very quickly also with qubit electronics and Far East?
Certainly. Let me see if I can share my screen. Can you, let's see, can you all see the screen?
Not yet, but I think it should come up.
Can you see it now?
Not yet. Yes.
Okay, so let me just pull this over. I have to look away from it. So, okay, very quickly, the question deals with cubic electronics. This deals with the famous vexed question of penalty clauses, which is an issue all around the world. The relevant legislation in Malaysia is Section 75. All Malaysian lawyers are familiar with it. And it sets out, and the key words are underlined, that it sets out where there is a breach. If liquidated damages are stipulated, you're entitled, whether or not actual damage is proved to have been caused thereby, a reasonable compensation. And there are 4 cases that deal with this, 3 Malaysian and 1 English, which I'll go through very quickly. Now, the first of these cases is Selva Kumar against Murugaya, which is a case about a quarter century ago, where the federal court adopted a restrictive interpretation of Section 75. Now, to be fair, this is consistent with Indian case law going back 70 or 80 years, which actually said that even if parties have agreed the amount of liquidated damages in the contract, an innocent party cannot just claim that amount. He must prove the actual loss suffered. And the only exception would be where the court finds it difficult to assess actual loss or damage, as there is no suitable measure of damages. And then this was reconsidered and affirmed by the federal court in the case of Johor Coastal in 2009. Now, let me just go to the next page. Okay. Into this comes a decision of the UK Supreme Court in Cavendish Square, very quick, which dealt with penalty clauses under English law. And what they said there was that the true test relating to enforceability of penalty provisions is whether the impugned provision is a secondary obligation which imposes a detriment on the contract breaker out of all proportion, and these are the key words, out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation. So in fact, they changed the law and they allowed enforcement, even deterrent clauses, as long as they were not unconscionable or excessive. Now, then all of this was considered by our federal court in 2019, a decision of Justice Richard Malandram, who modified. They didn't overrule Selva Kumar, but they modified it and said that the initial onus lies on the party seeking to enforce the LAD clause to adduce evidence that there was a breach of contract, and the contract contains a clause specifying the sum to be paid on breach, which is your classic LAD clause. Once these two elements have been established, the innocent party is entitled to receive a sum not exceeding the amount stipulated in the contract, irrespective of whether actual damage or loss is proven, unless the defaulting party proves the unreasonableness of the LAD clause. And if there is a dispute as to what constitutes a reasonable compensation, the burden falls on the defaulting party to show that the LAD clause is unreasonable. So it did two things. It reversed the burden. So instead of the claimant, the innocent party, proving that the sum stated in the LAD clause is reasonable, it is for the defaulting party to prove that it is unreasonable. And you are, generally speaking, entitled. There's a presumption that it is reasonable compensation. Now, there's a number of pithy quotes that I have quoted in here firstly, the federal court suggested without deciding you can't contract out of Section 75. Secondly, in para 57, they identified the very same passage and accepted the very same passage in the judgment of Cavendish Square, which I've highlighted there, that what you look for is it a secondary obligation? That is to say, it is compensation or damages and not a price adjustment clause. That it imposes a detriment, and that detriment must be out of all proportion to any legitimate interest. So you've now got new terms of proportionality and legitimate interest, which don't exist which didn't exist prior to this decision. And went on to say, only where the sum stipulated is unconscionably high and exorbitant by reference to legitimate interest in the performance, that such a clause is struck down. And 65, no necessity for proof of actual loss or damage in every case, which is quite different from Selva Kumar. Reasonable compensation is not confined to actual loss, although evidence of that may be a starting point. And then in 68, regardless of whether damage is quantifiable or otherwise, it is incumbent on the court to adopt a common sense approach by taking into account legitimate interest and the proportionality. So again, stress on that. And then they've summarized the principles and the key principles at para 74, Roman numeral 4, in determining what amounts to reasonable compensation. The concepts of legitimate interest and proportionality are relevant. A sum payable on breach of contract is unreasonable compensation if it is extravagant and unconscionable in amount in comparison to the highest conceivable loss which could possibly flow. And Roman numeral 6, Section 75 allows reasonable compensation to be awarded irrespective of whether actual loss or damage is proven. Thus, proof of actual loss is not the sole conclusive determinant of reasonable compensation, although evidence of that may be a useful starting point. So this is and then they went on to say that the initial onus, I've covered this in my original slide, which basically reverses the burden of proving that something is, if there is a dispute as to what constitutes a reasonable compensation, the burden of proof falls on the defaulting party to show that the damages clause, including the sum stated therein, is unreasonable. So that's a very quick voyage around these clauses and this case.
Why didn't you proceed with Far East and then we'll take the two together?
Okay. Far East, I think Jun Liang is doing it.
Oh, twice, yes. Jun Liang, why didn't you proceed with Far East? Because time has caught up and overtaken us.
I will, Judge. Let me just share the slides on Far East. Right, as most of you would know, Far East is now pretty much water under the bridge. If at all, it tells us what lessons are to be learned if Section 42 is to be brought back into our Arbitration Act in some form or another. Now, the facts of Far East and Majlis Ugama Islam are quite extensive, so I won't get into that. But essentially, the difficulty that the industry saw, or the industry largely saw with the Far East case, was the enlargement of the Section 42 test. Now, leading up to Far East, there were a host of cases by the High Court, by the Court of Appeal, which sets out the test for questions of law arising out of an award. In Far East, the Federal Court set out a list of areas or a list of questions of law which might potentially fall within this definition, and went on to say that Section 42 covers not a question of a law arising out of an award, but any question of law. So the concern, for example, if you look at item C on the list, is that where a decision of the tribunal was wrong, where there was an erroneous application of the law, where the correctness of the law applied and the correctness of the test applied is under question, these are all subject of a Section 42 challenge. Now, with that, of course, Section 42 has been viewed almost as an appellate provision, albeit on questions of law only, but it opens the door for very wide questions, or it opens the door very wide for questions of law to be used. So as an upshot of the Far East decision in 2018, Section 42 was removed from our Arbitration Act. Now, following that, some concern in the industry is that there is then too little of an avenue to challenge an arbitration award. We have Section 37, which is effectively limited to procedural challenges, procedural fairness, jurisdictional challenges, whereas Section 42 traditionally would allow clear errors of law arising from the award, which would have had a substantial impact on the parties, to be brought before the courts. And that was a way to police arbitration awards. From the material that I've seen in 2020, I think the Malaysian Bar proposed the reintroduction of Section 42 in some form. And I think what they were looking at is with a provision for leave of court. Of course, I think Datuk Nitin would be in a better position to speak about this initiative. And that's really where we are at. The other aspect of Far East is in respect of pre-award interest. The Federal Court interpreted the Arbitration Act 2005 as it then was, to limit the arbitrator's jurisdiction to only award post-award interest. And this is, of course, in the absence of a specific agreement between parties to the contrary. And that, I think, has been addressed to some extent by an amendment to the Arbitration Act 2005. So that's really where we are.
Thank you.
I won't spend too much time on that since it's now been overtaken by the amendments.
So we invite Hong Ling now to comment on the Cubic Electronics as well as Far East Holdings, just perhaps for about 3 minutes or so.
Just very quickly, I think Cubic is certainly a welcome development for the construction industry, in the sense that on the point of the presumption of the LAD, because without that, it is really meaningless to even have an LAD clause, and you will have created even more problem, because when you issue CNC, when you deduct LAD, then immediately the point in time, the legitimacy of even using LAD as a deduction will be put in question, because you haven't proven your actual loss. So that's why I think that the presumption is helpful to create that certainty. Not to say that the LAD can be justified, but that's another issue. But at least it creates that certainty that this is a contractual right, that the court is trying to allow the parties to enforce what is stated in the contract. But I think that there is also a conceptual problem there, in the sense that it looks like how we assess losses for LAD contract and non-LAD contract are very different, because for contract where you do not have a LAD clause, what you are entitled to will be your actual loss. So in a LAD scenario, it looks like we consider not just the actual loss, but a lot of other things as well. So if we have a two identical project, two identical scenario, two identical default, the two identical delay, all the facts are identical. The only difference is that one has an LAD clause and one do not have an LAD clause. You may end up having a situation where the one do not have LAD clause is confined to the actual loss, but the one that has LAD provision will be, the party will be entitled to a much larger sum of compensation. That may not be the intended outcome, where it becomes entirely driven by whether or not you have the LAD clause. It's a difficult balance to strike in that sense. And it also feels like we are moving the time scale of assessing damages from, if you do not have an LAD clause, how you assess damages is at the point you incur the losses. But when you have an LAD clause, because you consider not just your actual loss, plus many other myriad of considerations, you are assessing the losses at a different point in time. So that change in approach will actually result in, looks like it's entirely two different types of contracts at the end of the day. So this is my views on cubic. To me, it's still a positive development, but certainly it is not a total solution to the predicament that we are facing. So I think for Section 42, while the issue of the pre-award interest, that has to be addressed through legislation, but to abolish Section 42 altogether, to me, is maybe too harsh of a step to take, and too drastic, because surely an arbitrator cannot act beyond the law. And if now he completely forgotten about his basic contractual principle, then how are we going to challenge that award? You can't.
So it's an overkill. You're saying it's an overkill.
Yes, because certainly there will be errors, because in order to give that confidence for people to subscribe to arbitration, you must have that level of check and balance, not amounting to interference, but there must be some check and balance. And people will have that expectation that when I go before you, you will decide based on the correct law and apply in a way the correct principle. So you can apply the correct law, but somehow you have a different considerations. That's why you come to a different outcome. That's fine, that we all accept. But if you say that suddenly, let's say now you decide the case purely on Swiss law, when the law is Malaysian law, you didn't say so. But it's difficult to squeeze ourselves under Section 37 and set it aside. And what other remedies do we have?
So we appreciate the danger you're highlighting, the notion that an arbitration award might be immune from all attacks other than the very limited scope of jurisdiction and natural justice. All right?
Correct. Yes.
Now we call upon Niting to, thank you, Hong Ling. We call upon Niting to comment on the latest initiatives from the Bauer on Section 42.
Okay, just before I get there, I'd just like to comment what Hon Leng said about his concerns about the decision in Cubic Electronics. In fact, the Singapore Court of Appeal, in a case called Denka Adventech, last year rejected the test in Cavendish Square. And precisely on that ground, they said, look, at the end of the day, all you're entitled to is a reasonable compensation for your actual loss. This legitimate interest test and proportionality seems to suggest that you can actually get more than your actual loss, and that is not the purpose of a damages clause. So just to put that in perspective. Now, on the second point, we're really stuck on Section 42. There is a move to reintroduce Section 42. We really stuck between, the devil and the deep blue sea. On the one hand, the interpretation of Section 42 by the Federal Court in Far East appeared to treat arbitrators as nothing more than equivalent to a sessions court, where they could be the final court, final decision maker on facts, but any and every question of law was open season for challenge. And that would completely destroy arbitration. Honestly, it would destroy arbitration. Why bother going to arbitration if you can be rewritten? And it would also push arbitrations out of Malaysia to Singapore straight away. I would have advised my clients to push all their arbitrations to Singapore if Far East had not been statutorily reversed. But there is also a need to deal with the more egregious problems that can arise, which is you don't really want to make arbitrators in a jurisdiction perhaps like ours, which is not as mature as some other jurisdictions. You don't want to make an arbitrator like me, for example, into a tin pot god who is not bothered about the law and can make any decision he likes without caring what the law is, based on a sort of a Denning squared approach to the facts. So there is a need for that. So what is being proposed by the Bar Council is that we reinstitute a right to review, but only with leave, and with the leave provisions circumscribed heavily only on matters of public importance or where you're dealing with standard form contracts. In short, we would make our law similar to the law in Singapore for domestic arbitrations, and even the UK, who both allow leave in what essentially are codifications of the NEMA guidelines. So that there's some right of interference, but it's not on every matter.
Thank you so much. So now we will go for the general questions from the floor. The task of the moderator is pretty simple. I just deflect the questions to whoever I think would want to perhaps be passionate about answering the questions posed. Now, the first question has to do with our take on the Legenda Unggul's case. One practical way, it seems, to overcome the problem, as one of our participants had suggested, is why don't there be no retention sum? All sums are paid direct to the contractor, but the contractor in return give a BG to the employer. Wouldn't that solve the problem? We asked, was it Julian who was dealing with the case, to comment on it first?
Yes, Judge. That's one way to look at it, but from a practical standpoint, to provide someone with a bank guarantee involves costs.
Yeah.
If I'm not big enough and I don't have good enough a relationship with the bank, typically it's a one-to-one security. Whereas
but that's a lesser evil compared to my money being retained and compared to the uncertainty of argument as to whether it's trust money or under an insolvency regime, I have to queue up like all other unsecured creditors. It's a lesser of the two evils, isn't it?
It is a lesser of the two evils if we look at it from that aspect.
Yeah.
But typically, we have contractors who need an advance payment to even start a project. So to secure that payment bond, to secure that bond towards the retention sum might not be something that they can afford. Whereas in the typical way, you deduct it from progress payments, they feel it less.
But they don't give the bond until they receive the retention sum that is released. So at least they have cash flow there.
Well, by the time the retention sum is released, then there is no longer concern. It is the accumulation of the retention sum with the employer that really concerns the contractor.
Yes, so the employer releases everything, but in return, the contractor gives the employer a BG of some kind, so that any defective works can be taken care of.
Which means that on a typical structure, this would have to be done monthly. A bond towards the retention sum would have to be done monthly.
Yeah, the mechanics can be worked out, I suppose.
I suppose it's an alternative. Whether it's a practical alternative, I'm not sure.
You said that it all depends on the intention of the parties. So even after the party has progressed in the works, what if they confirm in writing that this sum of money is now retention sum that is held in trust for the contractor and is indeed put into a separate account?
That's a question for me, Judge.
Anyone, maybe Niti?
Okay, I'm sorry, Judge, I was slightly distracted, but could I have the question again?
You want me to repeat the question?
Yes, please, Judge.
Yeah. What if, since the court says that the words must be clear, so along the way, parties want to make it very clear in the light of this decision in the Legenda Unggul. So they wrote to each other and confirmed in writing that this sum of money retained is indeed trust money held in a separate account. Would that have solved the problem?
Yes, Judge. In theory, any form of contract would solve the problem. But in the practical world, I do not see an employer being delighted if having got a contract and a ruling in his favor, then turning around and voluntarily putting aside these monies, which he could otherwise use for his, for whatever things he wants to do, putting this money in a separate trust account and keeping it for somebody else. It's not going to happen in reality. That I think is the short answer to that. And going back to the earlier question that you posed to Jun Liang, this thing about giving a performance bond or a retention fund bond, it does happen, but the reality is, and let's take a step back, the vast majority of contracts do not have this problem with retention bonds. The monies are released in due course. You do get your retention monies flowing down. But getting a retention bond imposes an additional cost on the contract, as Jun Liang has said. So that proposal would impose an additional cost on subcontractors in all projects in order to deal with what is a very, very small minority of cases. And in a very cost-sensitive market like ours, it's, again, I think, not a practical solution.
All right, thanks. Now, with respect to cubic electronics, what if we explore the further mechanism that bankers would often use? A certificate from the innocent party would be kind of conclusive evidence that that is the amount incurred with respect to the losses sustained. Would that help to make it extra clear with respect to the ease in proving the reasonableness or proportionality of the amount agreed in the LED clause? Anyone?
Well, I think, Judge, I will have a stab at that. That, if at all, will only shift the onus of proof. Ultimately, I think the underlying issue is first the freedom to contract, and secondly, what is the quantum that is stipulated? Whether we go by the Dunlop pneumatic test, whether we go by the Cavendish test, the question of quantum, I think, proportionality versus whether it's a penalty. So I don't think that would resolve the issue. And I think even given cubic electronics approach, in practice, there will be some onus on the innocent party to prove the amount of the LED, or to prove a
very light burden to discharge, it seems, after reading cubic electronics.
Sorry, Judge?
A very light burden to discharge, it seems. You just proved that that clause exists and it's not unreasonable, or that it's reasonable.
Well, from a practical standpoint, I'm not sure, because based on cubic, the burden is on the other party to prove the unreasonableness of the LED sum. And how would he do that? He would say that of the X amount of ringgit that you're claiming per day, only 50% of it is your actual loss because of factors A, B, and C. So in reality, the employer will have to come back and say, look, it's not just A, B, and C, it's D, E, and F, and give some semblance of a figure. Although based on cubic, it seems that I don't have to prove, I don't have to absolutely prove the figures for D, E, and F, but I still have to show that D, E, and F are going to be losses that I encounter. So in reality, I think some onus of proof still falls with the employer given cubic. It's just that it's not as heavy a burden as in Selva Kumar.
But there are some LED clause where there is no cutting off limit. And so some innocent party can just drag it on and say we are prepared to wait for whatever reasons that would favor them. And so what should the defaulting party do in that kind of a situation?
There will always be SIPA, There will always be SIPA, I guess. Well, I look at it from two different timelines. The first one is that when the so-called LAD accrues and you exercise your right of deduction. The next one is you come to, in a way, a final determination, whether through arbitration or even just an interim determination through SIPA. So I think the importance of cubic is that because the presumption that you're entitled to charge a LAD, that will legitimize the imposition of LAD in accordance with the terms of the contract when the project is still ongoing. What I couldn't quite agree with cubic is that when you come to the true assessment of what should the amount of LAD that you should be entitled to, that should not go far beyond what a normal contractor is entitled, employer is entitled to charge in terms of proving their actual loss, because it cannot have a new set of rules just because that you have this fanciful line in your contract to say that this is your LAD. So, to legitimize the deduction, I think that is important. Otherwise, both parties will be living in limbo. That the employer say that, okay, so today I start to impose 10,000 per day, but he will be living in fear that 6 years down the road, when you assess the LAD, maybe your daily rate or the daily damages that you're entitled to is only 3,000. Then you got to cough out the balance 7,000 plus interest for the past 6 years.
I've come across clauses where people say, or parties agree when they enter the contract, that this kind of assessment of damages fall into that category where it is difficult to assess damages. And so they say we applied our mind to it. We won't challenge the, what they call mathematics of it. And so this is what we have agreed freely and voluntarily.
Yes, but I think ultimately that room is still there even within Selva Kumar, because we always forgotten that there's a second category of case in Selva Kumar where the court made it clear that if there is no known rule of assessing your losses, and I will presume that those line claims, the other claims will fall within that. So Selva Kumar is not so strict in the sense that prove every single cent and that's it and that's all and that's the end of the matter. No, the question is that are we able to prove that you fall within the second category as well? So if I open my hotel late, so what is my actual loss? How are we going to prove it? But there will be still a lot of the other kind of losses, which is difficult to actualize and to compute. And that actually falls within the second category of Selva Kumar. So it is still in line. The only trouble is that when we read this too literally, then that means the moment you're supposed to be entitled to LAD, you also already need to prove Selva Kumar. So how are you going to impose the LAD? How are you going to impose the losses? And once you impose, you over-impose in that sense, then later you become liable again. So that makes the entire LAD provision unworkable in that sense, very difficult to operate. So at least we clear the first hurdle in the sense that if there's a presumption that LAD, if the contract provides the right for you to impose it, you impose it, fine. Then you impose it. And later, if you found that you're supposed to pay less, fine, then you pay less. But you cannot be seen to be in breach of the contract by imposing more LAD and therefore also pay damages on that portion. So that is a part that where I find that it may be a little bit unfair and unjust.
Let's move to SIPA. So some say that in other jurisdictions, people have already thought about this. And so invariably in their act, they have a clause to say that the act applies to construction contract entered into after whichever date. Why didn't we learn our lesson from other jurisdictions? Because we could study UK, Australia, New Zealand, Singapore before we have our own act. So just put in that date and finished off with everything. Everyone would know how best to conduct their business. What do you think, Nitin?
That's a good question for the parliamentary draftsman. Maybe our parliamentary draftsmen have so much faith in the wisdom of our federal court that they thought, let's kick this question to the federal court and let them decide the issue.
But if it's a jurisdictional issue, does it matter when it has been applied to set aside? Julian?
I think from a legal standpoint, the answer is no, it does not matter. If there is no jurisdiction, there is no jurisdiction. But if one took that approach, things will be worse. It will be even more open-ended. So you're not even looking at the retrospectivity as we understand it to be. You are pushing it back even to cases that have been concluded. So like Kining Exeter,
Yes.
You can basically tell the party who has received payment to refund to refund the money and have the adjudication decision set aside. And I think that takes it too far back.
Yeah. So is there any cases coming up in the federal court that will revisit this element of prospective application of the decision?
Well, I understand from, sorry, Nathan, I understand that Kinning Exeter is now going
Before
up.
the federal court.
I'm not sure where it is at the moment.
I remember I decided the first round of Kinning Exeter. So I was probably the one who enforced the decision. I remember now. Yeah.
This was in 2017, according to the reports.
Yes. Now, meeting with respect to adjudication and the approach in which the courts have looked at accrued rights and separating procedural matters from substantive rights matter. What are your comments on it? Because they say if it's accrued rights, then for Parliament to override that, express language must be used.
I think that's correct. And that's why I think the decision is correct insofar as it applies to Section 35, that you cannot amend a contract freely entered into between parties without express legislation to that effect. That's quite different from saying that if I set up another court system, for example, or another dispute resolution process, that must also only be prospective, because that is not changing the parties' rights. In effect, what did SEPA do? Under most construction contracts, you have a superintending officer or an engineer or somebody on the architect who issues interim payment certificates that are valid until either a final account is done or there is an arbitration. All that SEPA really sought to do was to say, hey, there are some cases where this engineer or architect may be a little biased in favor of the chap who's paying him. So we will create this independent authority called an adjudicator who will issue in substitution an interim certificate of payment, which will be binding only until such time as you have an arbitration or a court case that resolves otherwise. I'm not sure why that was considered to be so inimical to existing rights that it had to be struck down.
I suppose if you drill down into the certificate, then you can see that some of the payments are due because of the fact that it is not a case of pay when paid.
That's 35, Judge, and I totally agree with 35. That's quite a different issue, though.
Okay.
As to whether there is a jurisdiction even for our adjudicators to decide on other matters, just simply what is the value of work done.
But it's interesting to note that even with going back to office, the number of cases for adjudication have not, as it were, piled up in some kind of a bottleneck. And is this an indication of a paradigm shift with respect to those in the construction industry, in that all people having suffered now, let's not agonize further by increasing each other's suffering, but look apart and see how best to perhaps harness arbitration or mediation to try to resolve some of these issues that we all find ourselves to be commonly affected?
Judge, I'm sorry, you have a very optimistic view of human nature.
Right.
I can tell you that since the start of the pandemic, the workflow that I'm facing and that, as I understand, other construction lawyers are facing has increased enormously. When cash dries up in the construction industry, you don't end up with people sitting down and saying how to suffer the pain.
People are driven to extremes, is it?
People say, this is my money, let me use it, you sue me. In 3 years' time, if I have to pay you, maybe I'll have more money then.
But somehow they're not pursuing the adjudication channel if the statistics are anything to go by, isn't it?
Yeah.
All right.
I'm not sure of that, Judge.
Yeah. Julian, any comments?
Well, I don't know whether, certainly if we are speaking about a Court of Appeal, Judge, whether it's the result of there not having been appointments for a period of time when we didn't have. So you might be feeling that gap now in the Court of Appeal.
Yes. That could be a factor. Well, we would love to answer all the questions, but time is against us. And so on that note, I think I must then thank all our speakers for their input. Don't worry about the slides, you'll be emailed to you as the organizer has told us in the chat group. And let me give them a round of applause, all of you, wherever you are, whether or not you prepared. And I hand you over to Weaving.
Thank you, Judge.
Thank you for reliving session 2 that was expertly moderated by Justice Dato' Lee Swee Sing. I hope you were able to refresh your memory into the findings of the 4 cases. Tomorrow, we'll be looking into session 3 that talks about whether to terminate or persevere in a contract. I assure you, it is a not to be missed show.
Look, you have got to pay attention to determination clauses. You've got to get advice so that you don't do it wrongly.
If you really don't have money, you cannot carry on with the job, then what the hell? No point suing me. No point taking me to adjudication.
Obviously, not everybody's contracts are being terminated. So perhaps
but
it's not all gloom and doom as painted.
Talk among yourself. Everything can be settled.
Why can't we do it in construction where the only thing is money, other than maybe ego, you know?
This session is worth skipping lunch.